Major breaking news out of Texas. The United States District Court for the Northern District of Texas in Fort Worth, in the case of Mock versus Garland, has found that the ATF's pistol brace rule is unconstitutional and illegal under the Administrative Procedure Act for various reasons. Explains why in detail the ATF failed to do its job in promulgating this pistol brace rule, including their reversal of a long-standing policy that these pistol braces were perfectly legal and did not have to be registered at NFA items or anything of the like. Let's break this down and what's going to happen next in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, I'm proud to say, Israel Disarm: What the 10/7 Attack Teaches Americans About the Right to Bear Arms. We must always learn from the mistakes of others. There's a lot of historical international evidence to support the right to keep and bear arms. I go into extreme detail about how the Israeli government, despite being a national security state and very good when it comes to intelligence, military, and security, simply dropped the ball by not allowing their citizens to carry guns and to have ready access to private civilian firearms. And the consequence, of course, as you know, that when seconds count, police are minutes away. And when it came to Israel on October 7th, when seconds counted against Hamas, the IDF and the military, by and large, were hours, if not days away from protecting a lot of these innocent civilians. 1,200 people were murdered by Hamas. Hundreds were taken hostage. A lot of this could have been dealt with much better, of course, if they were armed. And I have evidence on the ground to show that the areas in Israel that had armed citizens fared much, much better. Tell a lot of those stories, break it down in my relatively short book, Israel Disarmed. Check that out. All right, folks, major breaking news out of Texas. The United States District Court for the Northern District of Texas, Reed O'Connor, issued an opinion. I'll put a link to it down below that says that the ATF's pistol brace rule is illegal, not allowed, because it exceeded the authority of the relevant statute, and the regulations were no good for a variety of reasons. Again, you can take a look at the opinion yourself, but the bottom line is this: the pistol brace rule promulgated by the ATF as of the moment this video is being shot has been vacated under the Administrative Procedure Act. It is the remedy of vacatur. We'll talk about what that means in about 1 minute. The bottom line is that Judge O'Connor, in the case of Mock versus Garland said that there were two major mistakes made by the ATF in promulgating this pistol brace rule. He indicated there might be other problems with the rule, but there were two blatant ones that caused him to enter judgment, a final judgment against the ATF, and enter the remedy of vacatur against the ATF when it came to their pistol brace rule, which is, you know, basically saying that if you take a pistol brace and you attach it to a normal handgun, guess what? That somehow becomes a short barrel rifle and thus an NFA item, which is just plain dumb. But this Joe Biden administration, when it comes to gun rights, they don't care about the rule of law. They don't care about you. They just care about taking guns away because they got big plans for you and me, and they don't want us to have guns because it's a lot easier to boss people around and turn people into serfs and subjects if you're disarmed, which is exactly what the Founding Fathers understood could occur, which is why they gave us, among other things, the Second Amendment's right to keep and bear arms. Now, going back to this decision specifically, what Judge O'Connor said was two main points. The first one is he said that basically they adopted this final rule in a way that was arbitrary and capricious because they failed to explain why they did this big reversal in classifying what used to be a handgun with a pistol brace and perfectly fine. Now they reclassified that as an NFA item that needed to be registered under the NFA. Here is what the judge wrote. Check it out. The court finds that the adoption of the final rule was arbitrary and capricious for two reasons. First, the defendants did not provide a detailed justification for the reversal of the agency's long-standing position. And second, the final rule standards are impermissibly vague. For close to a decade, the ATF concluded that attaching the brace to a firearm does not alter the classification of the firearm or subject the firearm to NFA control. The ATF changed course on this position for the first time in 2023 when it issued the final rule reversing the agency's otherwise long-standing policy. When an agency changes course, as the ATF did here, it must be cognizant of the long-standing policies and be cognizant of the fact that long-standing policies may have engendered serious reliance interest that must be taken into account. Okay, big deal. This is the best argument in certain respects, not the only argument, that the ATF took a position with respect to these pistol braces for years and years and years, and only after the Biden administration came in with a clear anti-gun agenda and no real possibility of legislative success until moron John Cornyn came along and basically handed him a quote-unquote bipartisan gun control bill. I don't understand how John Cornyn is the senator in Texas, but you guys in Texas will explain that to me at some point. Nevertheless, the bottom line is there was no way that this legislation could get through Congress, so they tried to backdoor through the ATF through regulation. And of course, they basically took all these longstanding ATF policies and threw them into the trash bin and tried to enforce them. And the judge here says, no can do. You can't just reverse policy 180 degrees because, among other things, you have these major reliance interests, which you have millions of people that, in reliance upon longstanding ATF policy, went out and bought these items. And now you literally have converted them into being felons if they don't register it with the NFA. And that is what prompted the court to write the following. The court wrote, under the final rule, the ATF estimated that about 99% of pistols with stabilizing braces would be reclassified as NFA rifles. The ATF contemporaneously issued approximately 60 adjudications pursuant to the final rule that reclassified different configurations of firearms with stabilizing braces as NFA rifles. The ATF provided no explanations for how the agency came to these classifications, and there is no meaningful clarity about what constitutes an impermissible stabilizing brace. Now, the court also ruled against the ATF, basically saying that you have these impermissibly vague standards of what it is. Now, remember, there's a famous story about the Roman Emperor Nero. And you're like, Mark, why are we talking about the Roman Emperor Nero? It's because this is a story that as I recall, I learned from Justice Scalia many years ago. And he told the story that basically, when you would go into Rome under Nero, who was not the best emperor on the planet, and to say the least, very famous, but not necessarily Mr. Individual Rights, he would place the laws of Rome very high up on the Colosseum and these other buildings so that no one could actually read what the laws are. So it was very easy for people to trip up and violate the law, and he could punish people he didn't like because they violated the law they were never aware of, which gave rise to the modern Western notion of you need notice and opportunity to be heard before you go to prison. You got to know what the law is to follow it. And here you have Judge O'Connor saying that the ATF standards as to what is a permissible handgun versus a impermissible short barrel rifle with a pistol brace and so on and so on. He says these standards are so vague and permissible that no ordinary American could figure out what is allowed, what is not allowed. So you're going to have people becoming felons basically by mistake in the same way that Emperor Nero wanted that to occur. And I'm sure that Joe Biden and his administration wants us all to be felons so they can take away our gun rights and put us in prison and do things like that to us. I have no doubt that's their goal. They would love to be able to do that. We saw that on January 6th and how they're treating a lot of those people there. That's a video for another day. But this is what Judge O'Connor says specifically on that topic. He writes, the court finds that the standards set forth in the final rule are impermissibly vague. While the worksheet in the proposed rule would allow an individual to analyze his own weapon and gave each individual an objective basis to disagree with the ATF's determinations, the final rule vests the ATF with complete discretion to use a subjective balancing test to weigh six opaque factors on an invisible scale. Consequently, the court finds that the final rule's 6-factor test is so impermissibly vague that it provides no meaningful clarity about what constitutes an impermissible stabilizing brace, and thus that it is nigh impossible for a regular citizen to determine what constitutes a braced pistol that requires NFA registration. All right, folks, so there you have it. Major win today. Now, what's going to happen here is this is the remedy. Remember, there's two things, right? There's you win the case and then the remedy. It's like you're convicted of a crime and then you're sentenced. You win a lawsuit and then you get money or you get something good. That's the idea. So here, the remedy that was entered was the remedy of vacatur. Now, under the Federal Administrative Procedural Act, the remedy of vacatur means that the rule is null and void nationwide. It's been vacated nationwide. So what I think is going to happen, and that's very good, and we hope that happens and continues forever, by the way. But what I think is probably going to happen in the the real world. And, I'm not here to be rainbow and unicorn man. I'm here to tell you what I think is going to happen in the real world. I think what will likely happen, at least in the short run, is that either the U.S. Court of Appeals for the Fifth Circuit or maybe even the Supreme Court will stay this ruling at some point for a period of time while they take a look at it, because the Solicitor General and the Attorney General is going to ask it to occur. That doesn't mean if that's granted, we're going to lose the case on the merits, but just pay attention to what the DOJ and Merrick Garland's going to go. They're going to seek a stay to the Fifth Circuit, and we'll see what happens. They may get it, or maybe they won't. We'll find out more in the next week or two. But anyway, there you have it. Mock versus Garland. Congratulations to the plaintiffs, keeping up the good fight on pistol braces, and we'll report more as this story develops. In the meantime, don't forget to follow me on X at 4Boxes Diner. Subscribe and resubscribe. We're still trying to get to 150,000 subscribers. And don't forget to check out my book on Amazon, Israel Disarmed. I think you'll find a lot of good information about the Second Amendment in there. All right, folks, there you have it. And we'll talk to you again soon here at the 4Boxes Diner.
Orders up. Table 2A.